Time now for another version of Ag in the Courtroom, and joining us, Dr. Roger McEowen, who is an agriculture law and a tax professor at the Washburn School of Law in Topeka. Dr. McEowen, always great to catch up with you.
Good to be with you, Ken. It's I always enjoy our talks that we have, and I hope people find them beneficial.
Okay, the couple topics we want to hit this month, very interesting. One that's been in the news, and we're all kind of understanding it. We all understand that the Dean Foods, the big dairy conglomerate, filed bankruptcy, but many farmers started getting notices that they had contracts they needed to pay regardless if they had a place to deliver their product. This sounds very strange, but there is things in the law that you may have to proceed.
Well, yeah, dairy farmers that receive these letters do have to respond, and I want to make sure we're clear on that. These are not entirely bogus. They may not be entirely legitimate, but they're not something just to throw in the trash. You have to respond to it. What this involves, Ken, is a specific provision in the bankruptcy code that basically says if you did business with a debtor or with another business that then subsequently files bankruptcy, and you had business transactions with them, you got paid by them within 90 days of them filing bankruptcy, that the preferential payment rule allows the bankruptcy trustee, once that company files bankruptcy, to reach back and try to claw all those monies back that the debtor paid within 90 days of filing. And so that's what these demand letters from the law firm representing the bankruptcy trustee are all about. They're saying, well, you sold milk to Dean Foods within 90 days of them filing bankruptcy, well, you need to pay that back. And that could be several $1,000s worth. And so it's a big deal to these dairy farmers.
Is this something that's happened in other agriculture companies that, if it has, it's been a long time since I remember anything maybe of this significance?
Yeah, we went through this with the Verasun bankruptcy about a decade ago. Now, that really didn't touch Kansas too much. That was in Iowa, Minnesota, South Dakota. They had a plant or two in Nebraska. But that ethanol bankruptcy with respect to Verasun was a big deal. And the letters went out to corn farmers then saying, you sold corn to Verasun within 90 days, you got to pay the proceeds back of that sale. Now, I would say this. They can do that. There is a provision in the bankruptcy code that allows the trustee to do that. However, I think just about all of the dairy farmers have a legitimate defense, and it's known as the ordinary course of business defense. In other words, if you sold milk to Verasun in that 90-day preferential period before they filed bankruptcy, but it was in your normal course of doing business. You know, they buy milk every 2 weeks, so they come out and pick up milk, and you get a milk check, and you got your stubs and your receipts and all of that. You need to have your attorney put a letter responding to the Dean Foods letter. You need to have your attorney put a letter together showing, we do business, my client does business with them, it's in the ordinary course of business, it was a contemporaneous exchange of value, go away. And I think that that's the case. In fact, I don't think these letters really should have gone out just carte blanche. Dean Foods needed to do their research and pinpoint whether there were actually any dairy farmers that didn't sell milk in the ordinary course of business. I think the vast majority, if not all, of the dairy farmers can successfully assert that defense. But the point is, if you don't assert that defense, you will get sued, and that may be if less than 25,000 is in controversy, you can get sued in your home jurisdiction. But you don't want to go through that. So you need to have competent bankruptcy counsel put a response letter back responding to the trustee.
Dr. Roger McEowen is an agriculture law and taxation professor at the Washburn School of Law in Topeka. Let's take a break. Back with more in just a moment.